You're on.
Okay, great. All right, so Laura, somebody's going to be controlling that by the camera or whatever? Okay, beautiful. All right, welcome today. As Laura said, this is about estate planning, so if you're here about radial tires or some other thing that's happening elsewhere in the building, please feel free to leave quietly. Otherwise, otherwise you're in the right place. If you need, just outside here, there's bathrooms out there. There's also more snacks if you get hungry during the thing. It's supposed to last for about an hour. I'll be talking for 30 to 40 minutes, and then we'll have time for any question and answer at the end. Question and answer. I would love to spend the time to talk with you about general rules of estate planning. I ask that you not get into your own personal situation, too much detail. It really needs a one-on-one with an attorney, and this is not really the time or the place to do that. But there is a lot of good information, hopefully, that you can get and I can provide to you today. So, with that, my name is Dan Kraus. I am an estate planner. I've been doing estate planning as an attorney in Wisconsin for 25 years. I started with my grandparents' estate plan. As soon as I got out of law school, they said, hey, we don't want to lose our little homestead here to nursing home costs or the cost of assisted living. Can you help us? And having never done any of that type of education in law school, I said, sure, I'll give it a try. So I started reading up on this stuff. Law school doesn't teach you a lot of stuff. It teaches you how, it teaches you how to think like a lawyer. I went to law school in New York City. We learned a lot about contracts, and we learned a lot about the criminal law. We learned nothing at all about family law and divorces and such. But the area that I practice in, estate planning, elder law, and probate, we didn't really touch on. So it's all been a learning experience. But by now, hopefully I've gotten the basics down, and I've written a book, in fact, on estate planning, which some of you have in front of you there. A little bit about me. I'm very proud of my military history. At 19, I joined the Army. I was a medic for a while. I spent 21 years on and off in the military. I got out of the military for a while in order to be in the Peace Corps and then go to law school. I got back in, and I was not a medic anymore. I was an officer, a JAG officer. I did a couple of tours stateside while I was in the reserves. They called me up. It was a backfill position. Luckily, I've never been shot at, except for my friends in the neighborhood with BB guns. But this is a picture of me shortly before I retired. I did a little selfie there for, I'm not sure whatever reason, but I've got my BCGs on. Is anybody familiar with the military term, or maybe it's just an Army thing? BCGs? It's the glasses. And we call them BCGs. You go in, the Army gives you almost everything that you need. And if you have eyes that need glasses, they will give you the glasses. So you go in and get your Army eye exam, and then they order your Army glasses for you. And we call them BCGs. It stands for birth control glasses. They don't have any chemicals in them or anything like that, but we call them that because no one will go on a date with you if you are wearing those glasses. This is just a picture of the book I wrote, published in 2017. It's due for an update. I'm working on the second edition right now. We're going to boost a little bit more of the information about doing planning for nursing home expenses and that kind of thing. I do want to wait to see what's going to happen with Medicaid and the changes that are likely to come in Congress and this administration. So I don't want to rush into that because it may just be out of date within a month or two. Our firm, Kraus Estate Planning and Elder Law Center, has attorneys that focus solely on estate planning, elder law, and probate or after death administration for people. We don't do divorces. We don't do bankruptcies. We won't talk to you about mesothelioma, whatever it is that they talk about on the TV. We are strictly estate planning. We want to be a helper for people as they age, as they plan for what is inevitable and what is not necessarily inevitable, meaning death and taxes. Those are inevitable. Some people end up being incapacitated before death. That is not inevitable, but it is also something that we help people plan for, because it does need planning for a person that has Alzheimer's before they get to a point where they can't make decisions anymore. They really need to make sure that their ducks are in a row, their plans are done. That's what we do. We've garnered a lot of good reviews, etc. So, to start out, what is estate planning? Estate planning is essentially arranging your legal affairs so that you know what is going to happen if you die or if you become incapacitated. Not subjects that people like to talk about a lot. The conversations that I have with people are sometimes very uncomfortable, but they are very important. And we talk about what needs to be done to protect your children, to protect your wealth, and what happens when you die. We want to maximize the control of our clients so that they can control as much as they can. Sometimes we widen the sphere of control to the family so that the family has control instead of losing control to the state or losing control to nursing expenses, things like that. We try to save as much as we can on taxes. Planning can really help to avoid taxes. And also just to cut down on the problems that sometimes families have after a parent dies, meaning fights, arguments, mistrust, misunderstanding about things. Keeping family peace is a very important part of estate planning. Estate planning, at a minimum, everyone should have at least 3 legal documents that can help control their lives and their after death, what happens with their assets. The three-legged stool, as you say, of estate planning is a will and 2 types of powers of attorney, the healthcare power of attorney and the financial power of attorney. Without those 3 documents, you don't have what we would consider to be a comprehensive estate plan. Now, I'll tell you that the estate plans that we do for our clients involve about a dozen documents each for each person. But these are the main ones. These are the really, really important ones. Everyone should have these. So, reasons that you should do estate planning now. Why now? Because we don't know what's going to happen today or tomorrow in the future. You could lose capacity tomorrow. You could lose capacity today. Accidents, stroke, sudden illness. You might not be able to make decisions for yourself tomorrow. And if you haven't planned for incapacity, the government's got a plan for you. The government's got a plan for almost everything, and we'll talk about that. You can have your plan or you can go with the government's plan. So if you don't have plan for incapacity, the state law is going to control what happens with you, what happens with your assets, what happens with your health care if you become incapacitated. If you become incapacitated and there's nobody to make decisions for you because you haven't done powers of attorney for health care and powers of attorney for finance, then a guardianship has to be implemented, because otherwise no one else has access to make decisions about you, where you're going to live, what you're going to spend money on, and those kind of things. What's your health care going to be like? These kind of things, you need a person to be in control of that, and the person, if you don't have a plan, is going to be called a guardian. A guardianship means that you have a court supervising your life. Now, the courts aren't going to be calling up you every day and say, how are you doing? The way the court supervises your life is at the beginning, there's a hearing, a guardianship hearing, where they bring in the doctors, they bring in people that know you, they ask, why does this person need a guardianship? Also, if you're the subject of the guardianship, you would be wheeled into court or brought into court so that you can be present, because everyone has an opportunity and the right to object to a guardianship. And so even though it may be obvious to everyone that a person is completely out of it, doesn't know what's going on, they still must be brought into court and listen to the testimony of the doctor saying that they're unable to make these decisions for themselves, or they've been wandering out in the neighborhood, or they've leave the stove on, or they just are unable to even communicate or get out of the bed. These things happen in the guardianship court. It's something that you would want to avoid. That's the point I'm trying to make, is this is not a comfortable thing. It costs a lot of money. It happens in the courtroom, and you have to bring all these people together just to get somebody appointed to make decisions for you. If you have a nursing cost in guardianship, the guardianship court will not allow you to do some of the things that we like people to do in order to try to save assets for the family. Those are off the table once the guardianship is implemented. You can't do any controlled gifting. We help people to do gifting, but there's rules against it, so we have to do it in a certain way. The courts will not allow any of that stuff. You have unintended consequences of a guardianship. One of them is that you have no idea who's going to be your guardian. If you wait for it to get to this level and somebody has to bring you into court to do a guardianship, you might even get a guardian that you have never met in your life. Now, the courts try to find a family member, a responsible family member that will agree to do this, but you might have a family member that really wants to. And maybe their reasons for wanting to aren't the best reasons. Maybe they want to get control of your money. Maybe they just want to think that they know better than you do about things, and you don't know. Oftentimes, though, there's no family member who is appropriate or willing to do this, and so they reach out into the community for these corporate guardians. And many people have corporate guardians that they've never met before, and that just check on them once a month, and that's it. So if the person is in a facility like a assisted living or nursing home, they might get a visit from their guardian 2 or 3 times a year, and then the guardian has to report to the court once a year on your finances, and then they just keep, they handle the checkbook from their offices. The checkbook that has your money in it. And of course, we talked about the expenses and the embarrassment of the court guardianship process. So that's the government's plan for you if you become incapacitated. So if you want to get away from the government's plan, you can make your own plan, and the major tools are power of attorney for finances. You can appoint somebody that you trust to make financial decisions for you, to control your bank accounts, to be able to sell your house or get a mortgage or buy something on your behalf, make contracts, to do whatever. You can have a power of attorney that legally allows that person to do that. Wisconsin has a good power of attorney law because some states, in fact, Wisconsin before 2008, you could give somebody a power of attorney and the bank could just refuse to accept it, just for no reason at all. Now Wisconsin requires the banks and everybody that would deal with you have to deal with your power of attorney unless they give a good reason not to. And the only good reasons that are allowed is that they have belief or evidence that your power of attorney is not valid. That's the only reason that people can not accept the power of attorney in Wisconsin these days. So the other tool, of course, is the health care power of attorney. Now you've got essentially everything covered. You've got the person's their health care. The health care power of attorney also allows the person to decide where you're going to live. So it's anything really to do with the person. And then anything to do with your finances is covered by the financial power of attorney. We also like to see people have a living will. Now, a living will is not really a will, and some people get it confused with a living trust. But a living will is a document that allows you to say, pull the plug if I'm in certain circumstances. So the example of somebody who probably would have wanted to have a living will is Terry Schiavo. Does anybody remember that name from early in this century, 25 years ago? Terry Schiavo was all over the news. The case went to the Supreme Court. The Congress people and even George W. flew back to Washington from his ranch to make an opinion about what's going on with Terry Schiavo. It was a poor, unfortunate woman who had a heart attack in her 20s. I think she was 28 years old. She was married, 28, no kids. She had a heart attack for whatever reason, I don't know, but her heart had stopped long enough for her brain to have gotten not enough oxygen. When they revived her, the rest of her body was very healthy. All of her organs were working fine, but her brain was pretty much gone. Now, she was on life support for 15 years. It was 6 years of life support before her husband finally said, let's stop this. It's time to stop it. There's no hope. Now, unfortunately for him, her parents had a different idea about what was right. So that started the court battle. The court battle lasted for 9 years. It went through the Florida courts. It went all the way up to the Supreme Court. They threw it back down to the Florida courts. And finally, the Florida Supreme Court said, okay, you can stop feeding Terry through a tube. After they did that, Terry Schiavo died within about 8 or 10 days, and then the ordeal was over. They did an autopsy. There were a lot of people saying, Terry can hear me, I know she's in there. When I talk to her, she wiggles her fingers, her eyes move around. Then when they did the autopsy, they said there's no way that she had any kind of consciousness. Her brain was just so far gone. So in order to avoid that, people can do a living will. Also, the Wisconsin healthcare power of attorney also has some things in there that will allow a person to stop treatments and stop the feeding tubes that many people would want to have happen to them if they were in a situation like Terry Schiavo. Also, other things that you can do to plan for incapacity are using trusts. Trusts are something we haven't mentioned yet during this presentation, but trusts, there's many kinds of trusts and many uses for trust. And many people use trusts to control their assets during the time when they're still living. These trusts can be revocable or irrevocable trusts. They can help with taxes, but mostly they can help with protecting assets from creditors, predators, or just anybody that wants to try to get your stuff. Mainly, in this case, nursing care. Now, I'm going to be talking about nursing care, assisted living care, and I don't want to make the impression that I think that these people that run nursing homes or assisted living places are bad. They're not. They are providing a service that is really well needed, and some of them do it in a very good way, and families are happy with that. The problem with it is it costs a ton of money. Okay? It's not inexpensive to take care of somebody 24 hours a day. In fact, nursing care in this county, I think, costs about $14,000 or approaching $15,000 a month. And very few people make that kind of money. So what does that mean? You're spending your savings. So I'll get into that a little bit more later. All right. So the first reason was you could become incapacitated tomorrow. Reason number 2, you could die tomorrow. Any of us could. We could die today. Hopefully none of us will, but it's possible. It's going to happen to thousands and thousands of people tomorrow. They're going to die. Hope it's not us. It might be. So, once again, what happens if you die without a plan? State law is going to control. So, what does that mean? In general, the state law says your stuff is going to go to your closest relatives. Each state has its own state law. Depends on the state law as to what's going to happen. Now, a lot of people think that if you don't have a will or any kind of a plan, that your stuff is going to go to the state. Well, that's not really true for most people. Now, for some people, their stuff does go to the state because they don't have any relatives that are closer than first cousins. Okay? So, if people die, they have no spouse, no children, no parents living, no grandparents, no cousins, no nieces, nephews, no aunts, uncles, first cousins, and any descendants of first cousins. If there's nobody in that arena, then the state general education fund gets their stuff. Okay? But for most people, they have living relatives within that circle, and their relatives are going to get it according to what we call the rules of intestate succession. So Wisconsin rules of intestate succession control people who die within Wisconsin as residents of Wisconsin. All right. Also, if you don't plan, the state has a plan, but that plan has to be administered through the court system. Now, coincidentally, even if you have a will to plan your estate, that's also going to be administered through the court system. It's called a probate court. So things go through a court case. Some people say probate is a court case that you institute against yourself in favor of your people that you owe money. That's kind of an accurate description. Why would you sue yourself in order to get money to people that you owe? But it's kind of what probate is. It's not the real purpose of probate. It's to make sure that there's an orderly transition of dead people's stuff to living people. Because if we didn't have these kind of rules, we'd probably be back in the times when they didn't have the rules. Let's look at cavemen. What do you think happened when they died? I bet you that when they were sick, everybody would start grabbing their stuff. The strongest or the quickest or the sneakiest people are going to get whatever it was. And then some people thought that's not very fair, so they came up with this system. And this system has been going on for years and years, centuries and centuries. Before the United States was a country, we had things like probate. There are rules for this. Because the rules are so old, they get very complicated and they keep adding on, etc. Another problem that the state law allows 18-year-olds to have money, right? So as long as somebody is 18 and their parent has died or somebody has left them money, boom, they get an inheritance. What are they going to do with it? Nobody knows, but it's probably not going to be very smart. Now, in Wisconsin, in most cases, they have rules for what happens to a second marriage situation if one of the spouses dies. And this is one of the areas where we find people are most not well informed, or at least they don't plan for this. People have their first marriages, let's say, and they have kids, and then they get divorced and they find each other, and now they have true love. But I've got kids and you've got kids. And maybe we've even got one together. That's a complicated situation. So the state has to make rules about what's going to happen when one of these people dies. Because the general rule is, if you're married to somebody, they get all of your stuff when you die. But if you have children that are not your spouse's children, the rules change. Now the rules in Wisconsin say the children, your children, get half, and your spouse gets the other half. This is not usually what people would want. However, the state had to make some sort of rule, so they said, we'll make a rule, and then we'll make it easy for people to change that if they do a will. Everybody should do a will, so nobody has to deal with this rule. Well, I tell you, more than half of people die in this state without a will or without any kind of plan. So we have these fights between the children and the step-parent. Unfortunately, that's just a fact of life. Doesn't have to be that way. Let's talk about intestacy. So, people that die without wills. Now, this is getting to be a really old example. I should probably come up with something a little more modern, but most people still know James Dean, at least the audiences that I talk to. James Dean died in the 1950s. I think it was 1953 or 54. At the time that he died, he wasn't really even a big superstar at that moment because he had just finished a couple of movies that were released after his death, and those were the biggest movies that he was in. Rebel Without a Cause, and there was another one. He had been in a major studio production, one before that, and so he was starting to become known. Anyways, he died at age 24. He didn't have a will. No surprise, 24-year-olds don't usually have wills. But if you have a lot of money, or in James Dean's circumstance, if you have the potential to have a lot of money and you have a complicated family situation, really, really important to have a will. So what's the complicated family situation? Well, his mother had died when he was young. I think he was about 7 or 8 years old. His mom died. Now, his father, unfortunately, didn't step up to the plate. His father essentially pawned him off on his mother's sister, his aunt. His aunt raised him. They had a close relationship, and he didn't get along with his father at all. Unfortunately, state law in California, very much like state law in Wisconsin, doesn't matter who raised you, it's what's your family relationship. His father got everything, and so his father, who died I think in the 1990s, was very wealthy. Got several $1 million, $1 to $3 million every year from royalties because he inherited all the royalties and the assets of James Dean. The aunt didn't get anything. So, you can avoid intestacy by doing a will. The will also has some pitfalls. There is court involvement. Anytime you have a will, you have to have a court in order to make it valid. So, a will can be all done and properly notarized and witnessed and everything and stored properly, but after death, you can't just take the will to the bank and say, okay, it says I get everything, Mr. Banker, just hand me the bank account. It doesn't work like that. The banker is going to say, you need to take that will into the court. And then the court is going to give you a piece of paper called domiciliary letters, and then you bring that back to me, and then I will give you the money, and you can do what the will says. Now, you also have to pay all the debts and everything, which is obvious, or it should be obvious, but only the court can make that will activated. So, you have a probate process. You bring the will into the court and you say, okay, I want to get all the money. And they say, well, we have to open up a case called a probate court. You need to fill out these 12 forms before we can open up the probate. Oh, 12 court forms. All right, so let me try to figure this out. Anyways, it all goes through the probate process, and probates on average take over 13 months in Wisconsin these days. Wisconsin is not the worst. I mean, there are probates that I've been involved in, not from the beginning, thank goodness, that were over 10 years. They brought me in to close it up at the end. But one thing that bothers me more and more about probate is the lack of privacy. Because anything that goes through the courts, with some exceptions involving children, anything that goes through the courts is public. Anybody can show up to court and just sit through and watch all the hearings, watch all the criminal cases, watch all the divorces. It could be great entertainment. Some people do. They just sit in court because it's better than watching TV. It's real people. It's live. People just love Judge Judy and you remember Judge Wapner. These are popular things because you get to see the dirt happening in other people's lives. Well, you can also go and watch probate proceedings. Now, most of the probate happens outside of the court. The court just stamps off and the person goes and does all the banking and stuff. However, they have to report on that. All the paperwork goes into the court, and that's all public. Anybody can walk into the court. You don't have to be a citizen. You don't have to be a resident of the United States. You don't even have to speak English. You can go in and say, I want to see the file on this probate. And they will say, sure. There's a computer right over there. Here's the password. Just go in there, and then you can get into that file or any file that you want to look at. And so you can look and you can see all the assets that that person had when they died. You can see the addresses of all of their beneficiaries. You can see their names and their addresses. You can get all of that stuff as a public records. And you don't even have to tell them that what you're taking, what you're looking at. You can print out copies. You can take that home, and you can devise a way to try to scam these people out of their inheritance. Now, does anybody know what CCAP is? Yeah, CCAP is the Circuit Court Access Program. It's on the internet. And if you're curious, you can just go and type in CCAP, and Google will take you to a link, and then you have to click a thing that says you promise you won't use it for any illegal purposes, right? Nobody reads that, but you just click in, and then you can search any court case in the state. And you can see if your neighbors have been convicted of whatever. Domestic violence, battery, assault, criminal, whatever. You can look and see that. You can look into the divorces of your neighbors. You can look at your relatives and see whether they've gotten in trouble. And you can also look and see all the probates that happen in the state of Wisconsin, which also means that anybody in Pakistan or China or Russia or North Korea can also look and see where all the probates are happening in Wisconsin. And you know, they don't even have to get on their computer. All they have to do is train an AI bot to go and look and see all the probates happening in Wisconsin. And then they could train that AI bot to ring a bell in their little hovel that tells them when there's a probate that has assets more than $200,000 or whatever amount that they decide. And as soon as that bell rings, they go to the computer and then they download the names and addresses of all the interested parties in that probate, and maybe they send them a ginned up letter that says, congratulations on your inheritance. In order to make sure that we properly get you your money, we need your banking account information, your social security number, and please go to this website, enter that in, and we will make sure that all of your assets transfer to you in the swiftest manner possible. Guess what happens? A certain number of those people are going to do that. And then what happens? They lose everything in their bank account. Okay? So, the story that I'm trying to tell you is just to say that anything that goes through the probate court is public. If your assets and your probate after death goes through the probate courts, more and more, your kids, your heirs are going to be subject to people knowing that they have received assets and they may be a good target for some sort of a scam. So that invites predators. So a will gets you out of the intestate succession plan, but it still lands you in the probate court, which is not always that good. All right, so reason number 3, tied into that. You or your heirs could end up in court. Reason number 3 to do estate planning now, avoid that court stuff. So, how can you avoid court? For after death things, you can plan using trusts, revocable or irrevocable trusts, or a combination thereof. Revocable trusts, generally considered to be a will substitute. Starting in the 1980s, trusts started to become popular as, I'm not sure exactly why, but people realized that you could start using trust in order to skip over the probate process. And since then, They become more and more popular, and most of the plans that I do now for my clients involve revocable trusts, but more and more irrevocable trust as well. The way that trusts avoid probate is if you set up a trust, you get to control everything. You don't have to do an extra tax return. Once it's all set up, it's kind of on autopilot. You just live your life as you always did. Your bank account statements now is going to say your trust name on it. Your title to your house and your real estate tax statement is going to say your trust name on it. But other than that, your life goes on as it always did. However, if you've done it properly, at your death, everything is owned by your trust and not by you in your name personally. Now, the probate court is set up to transfer assets from a person, from a dead person, to living people. At the time of your death, if you've done this right with the revocable living trust, you legally, as far as the probate court goes, have nothing, because your trust owns it all, and a trust doesn't die. It can be terminated, it can stop whatever it was doing, but only after all the assets have been distributed to the people that you named in the trust. It's like a contract. So, as contracts go, all of us are subject to many contracts. Every time you click on something on the internet, you're signing a contract. But also, we sign contracts with ink. Now, most of those contracts, as we know, don't ever end up in court. We sign the contract, we follow the contract, other people follow the contract. If it's not working, we renegotiate the contract, etc. Only in the rare case when there's a big dispute, people take that to court. It's the same way with the trust. Everything is managed outside of the court system. Everything is managed in a private way that nobody has to see. There's no public filing. There's nothing to indicate even that you have died, except somebody can be watching your real estate or the trust real estate, and they'll see, oh, it's transferred hands after at this point in time. But none of it goes through the CCAP system. Nobody has to know anything about what's going on with a trust. So, preserves privacy, no public filing. It's controlled by you. Once you set up your trust, you can put all your stuff in there, including your house, your bank accounts, etc. And then you can change that trust. You can change who gets it on your death. You can change how it's managed during your life. You can give away everything that's in the trust. You don't have to ask anybody. It's just controlled by you. This is a revocable trust, very convenient and wonderful for your kids that they don't have to go through court. Irrevocable trusts are often used. Most commonly in my practice, irrevocable trusts are used in order to give control of the assets to your family member, normally your children, so that you can put your house in one of these and you live in it for the rest of your life, but you no longer own it. So if you get sued or if you go bankrupt or something, you don't have to worry about losing the assets that you put in the trust. But most importantly, those things in the trust are not liable to be used for the care of you or your spouse during your lifetime. Nursing home costs don't have to be paid out of anything in the trust, meaning that you can qualify for Medicaid if you've put everything into one of these trusts, and it has to be 5 years from then without getting a penalty. So if you put stuff in one of these irrevocable trusts, the type of trust called an MAPT, Medicaid Asset Protection Trust, very common term, MAPT, allows you to put assets in there. Then after 5 years, the county and the state can't even ask about those assets, and then you can have fewer assets so you don't have to spend everything on your nursing care before you can qualify for Medicaid to pay for nursing care, to pay for long-term care, to pay for even some health care at home. Medicaid can pay for that, but the rules are they can't pay for it unless you're down to about $2,000. So most people in the state's plan for that is different than what your plan should be. You can use irrevocable trust to preserve assets. There's other types of irrevocable trusts that are used for special needs. You may have heard of special needs trusts for special needs people. If a special needs person is on SSI, let's say, they get money every month so that they can pay for the things that they need because they're not able to work, they're disabled. But if they inherit something, now they get knocked off of that until they spend their inheritance on all the stuff that they were getting. In fact, they lose a lot of the social services that they could get if they were on Medicaid because they've inherited something. Now they have to pay for all those services. They have to pay for everything until they run out of that money, and then they can apply again for those services. So we use special needs trust to protect assets for special needs people. There's other things that we do with irrevocable trust. There's ways to reduce taxes, specifically in charitable situations. If people want to give a lot of money to charity, they can get good tax deductions with using these kind of trusts. All right, reason number 4 that you should do estate planning today. You could owe death taxes. Now, for most people, in fact, I would wager a guess that nobody in this room needs to worry about estate taxes. And why is that? Because I still haven't changed this. This is last year's number. Now it's 13.99 million. If you die with more than 13.99 million, then you need to pay an estate tax. In Wisconsin, there is no Wisconsin estate tax anymore. We only pay the federal estate tax. So this is the death tax that some people on TV are always saying we've got to get upset about. What I'm telling you is 100% of the people, rounded to the nearest percent, is 100% of the people don't pay a death tax. 99.8% of the people in this country don't pay any death tax. So when they're screaming about that on TV, you can say, I don't care about that. Because really, the big boogeyman is you could run out of money for other reasons. Nursing costs. So this is the bonus reason. Reason number 5 that you should do estate planning today is because the real boogeyman towards the end of life is not the tax man for most people. The real boogeyman at the end of life is the cost, the high cost of nursing care and assisted living memory care. This takes hundreds and thousands of people's assets, and they die with nothing, being able to give nothing to their children and having no security at the end because they've spent it all on their care. So this is a complicated slide. There's 2 types of planning that we help people with regarding nursing care and long-term care. And one is pre-planning. That's when we think a person is fairly healthy. They have a good chance of not needing any type of long-term care for at least 5 years. 5 years is the key because 5 years is the look-back period, and they're under federal law that they can look back and see what you've given away. And they can penalize you for that, but only for 5 years. So if you give something away now, and then you don't apply for Medicaid for at least 5 years from now, they can't ask about it. They can't care about it. They can ask, but it doesn't make any difference, right? So that's pre-planning. It's setting aside assets before you need to apply for Medicaid. We also do crisis planning, and just like it sounds, that's when we have a crisis. Somebody needs long-term care right now. It's going to be very expensive. Either we've already started paying for a nursing home. We've helped people that have been in nursing home for over 3 years, and we can still plan. It's not too late. There are times when it is too late. So let's imagine that person's been in the nursing home for 3 years. They don't have any powers of attorney. They are not able anymore to sign things because they don't understand things. Now it's too late. If they had done a power of attorney 20 years before that allows for this type of planning, then it's not too late. Their kids can sign whatever needs to be done. Okay, so crisis planning, we can save much more than the government's plan. We can't save as much as we can if you've done aggressive pre-planning, but still it's not too late. So this type of planning, some people say to me, that doesn't sound right. It sounds like you're cheating. Sounds like we're cheating. It's not right. It's not good. We're going to go to hell for that, or at least spend some time in purgatory if we do this kind of stuff. Well, I'm here to tell you that there's nothing wrong with it as far as I'm concerned. Now, the reason that I believe so is because the type of planning that we do helps people avoid a discrimination that is at the root of why people run out of money at the end of life paying for nursing care. And the discrimination has to do with the rules around Medicare and Medicaid. Now, they sound very similar, but Medicare is something that everybody gets when they're 65. As long as you've worked in this country as a citizen or a permanent resident and you paid in to the Medicare system, you qualify for Medicare. At 65, you sign up, and now your Social Security money, the Medicare money that you've paid in, starts paying your medical bills, at least 80%. And then you get a fairly inexpensive Medicare supplemental policy that makes up the rest. So, if you have cancer, Medicare pays. If you have a heart transplant, Medicare pays. If you have any kind of surgery, Medicare pays. Here's the discrimination. If you have Alzheimer's disease, you pay. If you have Parkinson's disease, if you have COPD, you just need help every day doing the things that need to be done in order to keep you healthy, clean, alive, fed. Your care is in a long-term care facility, or you need long-term care, and that has to come out of your pocket. Now, why is that? Nobody chooses whether they're going to get cancer or Alzheimer's disease. It's not just good people that get cancer and bad people get Alzheimer's disease. That's discrimination. Now, it's not illegal because it's based on the care that you need. So we help people avoid this discrimination by helping them to try to get the type of insurance that they've paid through their whole working lives to get. And now if they're unlucky enough to need long-term care, they don't get any of it. So by doing planning, we can help people avoid that discrimination. That's why I don't have any qualms about helping people do this. It's not a trick. We don't hide anything. We don't keep secrets from the government. When we help people do this, in fact, we help them get on Medicaid, and we open up the books. We show them. We said, we did all these things, and now they get to save all this money. And sometimes the county workers shake their head, and they say, we don't like people doing this, but they know that it's within the law. The county uses the law for the county's purposes. The facilities use the law for the facilities' purposes, and my clients use the law for their own purposes. We watch out for our clients and their families, not for the facilities and the government. What's the government's plan? If you need long-term care, their plan for you is you spend down until you have nothing but these things left. Now, the big thing, look at that, the home. They let you keep your home. Some of my clients say, wow, it's wonderful. I don't need any kind of planning. I like the government's plan. I can keep my home, and therefore the kids will get it. Oops, sorry, the government has phase 2 of their plan, which is called estate recovery. Even though you can keep your home while you're in the nursing home, once you die, the government gets to put a lien on it to repay all that money that they paid for the nursing care. So, unfortunately, it doesn't work the way that you would hope it would, and now your kids still don't get anything. Also, a lot of times, and I don't know if any of you have been through this, and like I said, I don't blame the nursing homes or the assisted living facilities. They need to make a profit. And they make more profit when people are private paying, because the Medicaid amounts that go to these facilities is less. Okay? So they want people to private pay. And what do they do when the person runs out of cash? They tell the family it's time to sell the home. Even though they wouldn't have to sell the home, but the facility won't tell you that. Rarely. You need to go to somebody that has your and your family's interests at heart, that can interpret the rules in a way that helps you and not the facility and not the government. But they've clamped down on these rules a lot, so that it used to be that you could save your home by putting it in a revocable trust. Anything that avoided probate did not get collected against at the end. But they changed that in 2014. Now they collect from revocable trust, they collect from life estates, they collect from TOD, POD accounts, they collect from life insurance policies. They'll collect from all of these things through the estate recovery program. So that's the government's plan. Your plan should be keeping the house for you and then for your kids, or the farm, or the business, or your bank accounts. Keep money for your security during the time that you might be in a nursing home. What happens to a lot of people, and it's probably not the worst part of this, that your kids don't get anything when you die. The worst part of it is, at the end of your life, you are penniless. You are completely dependent on the government for everything. That is the worst part of this. You don't have money to make choices. If you wanted to move from this facility to that, you don't have the money to pay anybody to move you. You don't have the money to hire a moving truck. You don't have the money to get a massage once a month if you want it. Medicaid's not going to pay for all of that. All you get, they give you $45 a month to buy shaving cream, toothpaste, get your hair done, your nails, to buy new prescriptions, buy socks and underwear, $45 a month. That's all they let you keep of your income if you're on Medicaid. So isn't it better to have your kids holding on to some money for you so that they can buy you the things that you might need, or get you out of that place if it's necessary? So we help people, and a big part of that is using irrevocable trust. Once again, I said MAPT, Medicaid Asset Protection Trust. The 5-year look-back period applies. So if you're going to shift some of your assets into one of these MAPTs, you need to do it with the plan that you're not going to apply for Medicaid for 5 years. Now, if you have to apply for Medicaid within that period, or if you run out of money, there are things that you can do. It's not the end of the world, but you can't save as much as you can if you do have that 5 years. It protects the assets for your security during your life, as long as your children are trustworthy. Okay, I want to make that very clear. If your children decide to double cross you, there's nothing that you can do about it, because you have to hand over full legal control to them. You can't sue them for that money. You can't cajole them for that money. If you don't have moral control over your kids, then you probably shouldn't be doing this kind of stuff. Okay? And I've had a lot of clients that don't have kids, or they don't have kids that they trust, and they don't have another close family member that they trust, and I say, really, we can't do this kind of planning for you. You cannot name a bank as a trustee for one of these types of trusts, because they will not do it the way that you want it done. Okay. If you need the assets back, as long as your kids cooperate, there's the back door. The assets cannot come directly from the trust and go to you. They have to go to your descendants, and then they can gift it back to you. That's the back door. These trusts that we're talking about, you can draft them in many different ways. A lot of estate planning attorneys don't do this kind of planning because the county really scrutinizes it, or they haven't been trained in it that well. We know how to do it, but there's different ways to draft these trusts. We usually draft them so that they can avoid capital gains taxes on your house when your kids sell them in the future. Some people take and they say, okay, what I want to do now is give my house to my kids. I'll just give it to them, I'll keep living in it, and then I'll avoid losing the house in case of nursing costs. And that works. There's several downsides to that compared to the irrevocable trust, but one upside is they don't have to pay me to set it up, right? They just do a quick claim deed, they give the house to the kids. The downside, one of the big downsides of that is tens of thousands of dollars in capital gains tax that the kids will have to pay after mom and dad die and they sell the house. Imagine mom and dad bought the house in 1985 for $80,000. Now it's worth $500,000. What does that mean? That means there's $420,000 of capital gains sitting in that house. It's not dangerous as long as the house is not sold. If mom and dad sell the house during their lifetime, they don't have to pay the capital gains tax because it's their residence and they get a $500,000 exemption against paying capital gains tax on a residence. But if they give it to the kids during their lifetime, the kids get their basis in the house, meaning the kids have to deal with that $80,000 basis when they sell the house for $500,000 after mom and dad dies. The tax, the capital gains tax on that property is going to depend on the kids' tax, where the kids are as in their tax levels. Can't think of the tax strata. Tax bracket, thank you. The tax, it depends on the kids' tax brackets, but we're talking about a minimum of 15%. So let's take 480,000 times 15%, it's over 40,000. Probably close to 100,000 that we're talking about that the kids are going to have to pay tax on that house that could have been avoided if they'd had spent a few dollars on an irrevocable trust. I've seen this happen. Also, problems if you give your kids the house, if the kid then gets a divorce, your house is now part of that divorce problem, okay? Because the kids own the house and you don't own it. If the child gets sued, if the child goes bankrupt because of bad economy or medical problems, then your house is sucked into that bankruptcy. You might lose your house, but you can't lose it if you put it in one of these irrevocable trusts. It is not subject to their debts, their divorces, their problems. Also, you get the step up in basis, so they save several thousand, tens of thousands in capital gains tax in that. Okay, so now at this point, I would love to take any questions. I know I've talked for a long time. Yes, sir?
And then you said a few dollars. What is a few dollars?
So in which context?
For the
You filling out the trust.
Oh, okay. So great question. You get the mug. There's Laura. She's giving you the mug. All right. What?
It's got Kraus estate planning on one side, and this side says disinherit that special someone.
All right. The question: how much does it cost? It doesn't. It's not cheap. I'll tell you that. And it depends on what you need. Now, compared to what you're going to spend afterwards, you either pay now or pay later. For single people, depending on what you want, plans will start at about $3,500. For couples who want to do the whole gamut and maybe even do estate tax planning because they have several $1 million, it can be up over $20,000. I would have to take a look at your situation, and that's one of the things that I'm inviting you to do is to set an appointment, talk with me, and see whether there's something that we have to offer you that will work. At the end of a meeting with me or with our other attorney, we will give you a quote and tell you exactly what it will cost to set something up. We do this on a flat fee basis. You know before you have to spend a penny how much that's going to be. But like I say, we start plans at about $3,500. So if that's beyond your budget, then there's a lot of other resources, and there's other attorneys out there too. We are not the least expensive attorney, but I think that we're the best. Yes, ma'am.
Is the consultation free?
The consultation costs $200, and we give that back to you if you make your appointment. So we either put it towards a plan that you buy from us, or we refund the money. We have so many problems with people making appointments that they don't come. It messes up our schedule. So we charge you to make sure that you're serious about it, and we also require that you fill out information with family stuff and your assets so that we can really dig in during that time. If you don't fill out the form beforehand, then we cancel your appointment and we give it to somebody else, because we want to make sure that you're serious about this and that we can give you the most value that we can during that 1 hour time period that we're talking. Yes, sir.
Two questions, kind of similar. You did mention TOD, and
Yes.
so I just wanted to know, like bank accounts and so forth, does that go through probate or not? The other one was, I didn't hear you talk about beneficiaries for insurance policies, 401ks, etc. How does that work with and without a trust?
Okay, so great question. TOD, POD. TOD is transfer on death, and it's for anything besides cash. POD is pay on death, and that goes for bank accounts with cash in them. I made a chart here. I don't know if you can see this, but these are different ways to transfer assets upon death. How do you do it? You can put somebody on as a joint owner with rights of survivorship. So what some people do towards the end of life is they put their kids on their home as a joint owner. You can do this with bank accounts as well. And so, does this transfer the property on death? Maybe. Now, the maybe is because what if you and the kid are in the car together and goes off a cliff or something like that? Then it's not going to work. That joint ownership, now both joint owners are dead, and it fails. Does it avoid probate? The same reason. Maybe, because we don't know whether that person is going to survive, etc. If you're transferring property to people who might be younger than you, or really young, grandkids, etc., in school, is it going to allow you to keep that property for them, or somebody to keep that property for them until they're more mature, like 25? No, it's not going to do that. So with the POD and TOD, you can see have most of the downsides of doing things as joint ownership. However, with the POD and TOD, you can always change that. It doesn't stop you from selling those assets or getting rid of those assets without asking those people. It doesn't allow you to manage the assets in your incapacity or the incapacity of the person that you're giving it to. So there are some